So, good evening class. Tonight we will be talking about Title 17 of the Revised Corporation Code of the Philippines. This will be the last topic. This is the last title. So, this will be our last discussion for our class. So, tonight we will talk about the miscellaneous provisions. So, di ko alam kung ba't i-discuss ko pa to eh. Pero anyway, please let's begin with 173. Outstanding capital stock. We already touched this when we discussed section 6 in title 1. So anyway, yung outstanding capital stock will include all shares of stock issued to subscribers or to stockholders which are already fully paid. If not fully paid or the payment is only partial, obviously, as long as there is a binding subscription contract between subscriber or a stockholder, yung kanilang mga shares are considered pa rin as part of the outstanding capital stock. So remember class also that outstanding shares of stock is not necessarily an issued share, but an issued share may not have the status of an outstanding share. So pagka outstanding ang share, lagi yung issued, pero yung mga issued share hindi siya outstanding lagi. Kasi remember yung treasury shares. Treasury shares are already issued shares that are reacquired by the corporation. So meron silang status na issued, but because they are in the treasury, remember they are not outstanding shares. So basta outstanding shares, laging issued yan. Pero pagka issued share, it is not necessarily outstanding. So para maging outstanding ang share, the share of stock must be held by persons other than the corporation itself. So, yun ang kailangan nating tandaan when it comes to outstanding capital stock. In section 174, governing boards designation. So, remember, this will the authority given will cover only non-stock corporations as provided for in Title 11 and also special corporations as provided for in Title 13. So the special corporations referred to here are yung educational corporations and yung religious corporations only. So this is common practice already sa mga non-stock corporations where the governing boards are called names other than board of directors. Minsan, nakikita natin board of regent, board of governors, etc. etc. So also, please take note na yung mga educational corporations under title section 1 of title 13 may be organized as stock corporations. So, please take note also that the SEC has the power to collect fees. So, SEC is authorized to collect, retain, and use fees, fines, and other charges pursuant to the revised corporation code, its rules, and regulations. So, yung lahat ng fina-file natin sa SEC, may bayad yan. So, kung mag-file tayo ng articles, mag-amend tayo ng articles, bylaws, mag-increase tayo, decrease ng capital stock, etc. etc. Lahat ng bagay may bayad kasi wala nang libre ngayon, ano? So, anyway, the amount which will be collected by the SEC will be deposited and maintained in a separate account and will form a fund for the modernization of the SEC and also to augment the operational expenses of the SEC. So, remember, yung fees imposed by the SEC is collected for purely regulatory purposes in the exercise of police power. So, sufficient amount lang to cover the expenses of direct regulation. Hindi ito tax, remember. They are only for regulatory purposes. What else? Yung fees, etc. may be revised. So, by recommendation to the President, the SEC may revise yung or alter or amend or adjust yung charges and fee which by law it is allowed to collect. So remember, if the fees and charges are collected under rules and regulations promulgated by the SEC can change it on its own discretion. So kung nasa memorandum, nasa rules na ginawa mismo ng SEC yung collection ng ganong klaseng fine, remember, this is allowed already in the revised corporation code. Pwede niyang palitan kasi siya yung gumawa ng rules and regulation na yan. But if the charges and fees are imposed by law, remember, the SEC cannot on its own discretion yung revise, alter, or amend or adjust yung fees na yan. There must be the recommendation to the President, and it is the President which will revise, alter, amend, or adjust yung fees. So, yun ang kailangan nating tandaan. So, President will order yung revision, alteration, etc. or adjustment of the fees. So, yun ang tandaan natin sa 175. In 176, yung stock ownership in corporations vested with public interest may be limited by the NEDA or the National Economic Development Authority. So, yung corporations declared to be vested with public interest, pwedeng ilimit ang mga stockholders niyan, especially if it belongs to individuals or group of individuals related to one another by consanguinity or affinity, magkakamag-anak, yung consanguinity sa dugo, yung affinity naman, magkakamag-anak, yung mga in-laws, yan, by affiliation or relationship or by close business interest. So, this is necessary to remember, achieve national objectives, prevent anti-competitive practices, and also to prevent monopolies, etc. and restraint of trade. So, yun ang kailangan nating tandaan. In section 1, anyway, in addition to that, NEDA will make a time-to-time determination of whether the corporate form has been used to frustrate provisions of applicable laws and submit the findings to the Congress. Also, please take note of the reportorial requirements of the SEC. So, SEC is allowed to order the submission of the following reports and within such period as may be prescribed by the SEC. So, obligatory itong pagsasabit ng reports under Section 177, under Section 161, meron pang punishment, again, 10,000 to 200, if injurious to the public, 20 to 40,000 pesos. So, the reports to be submitted to the SEC are as follows. Number 1, the annual financial statements audited by an independent certified public accountant. Nagkaroon natin to dati. If the total assets, total liabilities are less than 600, financial statements shall be certified under oath by the treasurer or chief financial officer of the corporation. Also to be submitted to the SEC are yung general information sheet. What else? Yung if the corporation is vested with a public interest, director or trustee compensation report, magkano ang sinisweldo ng bawat isang director, magkano ang sinisweldo ng bawat isang trustee, and also yung appraisal or performance report. So also the standards or criteria used for assessment. So, if yung corporation does not submit these reportorial requirements, it may be placed under delinquent status if the failure is 3 times consecutively or intermittently within 5 years. So, SEC will give notice to and coordinate with the appropriate agency na that it is placing itong corporation na to under delinquent status. Please take note also that reports are confidential. So, and the SEC may also redact confidential information from the required report. So, please take note also of the visitorial power of the SEC under 178. So, this is the power of the state through the proper government agency to examine business affairs, administration, and conditions of the corporation. So, hindi lang SEC ang may visitorial power. So, other governmental agencies are also have visitorial power such as yung yun nga, SEC, BIR, also Insurance Commission, Bangko Sentral, also NTC, DOLE, and COA. They also have visitorial powers. So, ang kailangan nating tandaan sa visitorial power ay yung kanyang nature. So, public right. So, what else? The purpose of visitation is to supervise and control the management of corporation and also to to keep them within the limit of their power. The scope is any corporation which transacts business in the Philippines. So obviously, it can apply to special corporations or those which have special charters or those that are created by special laws, and also to foreign corporation. What else? Revocation of incorporation if there is refusal or there is obstruction of the exercise of the SEC of its visitorial power. This is without prejudice to other imposable penalties under the revised corporation code. So also, please take note that all interrogatories are confidential. And also the answers which are given to the interrogatories by the corporation are confidential, unless again class it may be of public interest, as we have already discussed in title 16. Remember yung exercise ng investigative power, the findings may be published. So ito yung exception sa confidentiality rule when otherwise provided, as we already discussed, and also to protect the public interest. Yan. Also, they will be presented as evidence in court. So, please take note also of the powers of the SEC. So, yung powers of the SEC, marami yan. It is enumerated under 179. It will exercise supervision, jurisdiction, control over all corporations. What else? It will retain jurisdiction over intra-corporate disputes submitted as of submitted for final resolution. Also, yung proceedings for suspension of payment or rehabilitation cases. What else? Sanctions for violation of this code. So, pwede siyang mag-implement ng mga punishment for violation. What else? Take note also that the SEC can promote corporate governance and protection of minority investors by the issuance of rules and regulations which are consistent with best international practices. They can also issue opinions para lang maklarify yung mga doubtful portions ng laws and regulations. What else? Issue cease and desist order para to prevent damages. What else? Corporations may be held also by the SEC in direct or indirect direct or and indirect contempt. So we have already discussed that when we discussed title 16, yung cease and desist orders na discuss na natin, at saka yung contempt. What else? Subpoena duces tecum. So ito, SEC can summon witnesses, in short. Tapos pagka naman subpoena duces tecum, summon a witness, and the witness must bring documents to to the SEC. What else? Examine, order, search and seizure of documents, papers, files, and records. So, hindi lang bastang i-examine, pwede ring i-search, pwede ring i-seize yung mga books na yan, which will aid in its investigation. What else? Suspend and revoke certificate of incorporation, but always after proper notice and hearing, and dissolve yung corporation if it is guilty of securities violations, smuggling, tax evasion, money laundering, etc., etc. What else? It can also issue writs of execution or attachment to enforce payment of fees. In short, yung mga ang SEC can issue orders to freeze or sequester yung properties ng corporation, pambayad ng mga fines and other duties. What else? Number of independent directors, pwede ring i-prescribe ng SEC yan, and also yung minimum criteria for determining independence. So, impose or recommend new modes by which stockholder, member, director, or trustees may attend meeting or cast their votes as technology may allow. So, pwedeng mag-suggest ang SEC ng bukod sa video conferencing, hindi ko na alam kung ano pang mas pwedeng improvement pa from video conferencing. So anyway, we will see what technology will provide us in the future. Also, SEC may formulate and enforce standards, guidelines, policies, and regulations to carry out the provisions of the revised corporation code, and very important, such other powers which are necessary or incidental to carry out the express powers of the SEC. So also remember, class, that the Court of Appeals and the Supreme Court are the only ones who can issue a restraining order or preliminary injunction or preliminary mandatory injunction against any act of the SEC. So ang pwede lang, madaling sabi para hindi na tayo mahirapan lahat dahil these are very technical terms. For law students, not. Pero syempre, accountancy. So anyway, ang Court of Appeals lang at saka ang SEC ang pwedeng mag-stop ng mga actions ng SEC. Yung actions ng SEC, remember, are in the exercise of its powers, duties, and responsibility. So kung gusto nyo ma-stop yun, punta kayo sa Court of Appeals. The Court of Appeals will issue a restraining order, preliminary injunction, or preliminary mandatory injunction to the SEC. 180, electronic filing and monitoring system. Inumpisahan na nila to, although palpak ito. Kailangan sa madaling araw ka mag-register, Google Chrome pa. Tapos, ang bagal pa. Anyway, it's a nightmare. Mas maganda pa yung manual na dati. Pero again, this is my personal opinion only. So what else? Arbitration for corporations. This is a new provision talaga. Hindi ito kinuha sa dati. So remember, class, arbitration agreement may be provided in the articles. So nakalagay sa articles of incorporation na mayroong arbitration agreement. So kung mayroong intra-corporate dispute, i-arbitrate muna, pag-usapan. So pag-uusapan, tapos mayroong isang arbitrator, the arbitrator will decide. So yun ang, before it is filed to the courts yan. Kung hindi ma-solve, doon pa lang pupunta sa court. So anyway, arbitration is recognized as a mode of, as an alternative mode to litigation. Mas mabilis kasi ang arbitration at saka practical daw. So, kaysa naman makipag-laban ka sa korte ng sobrang tagal, pwedeng arbitration na lang muna. If there is an arbitration agreement in the articles of incorporation. So the subject matter will cover only disputes between the corporation stockholders or members. So the dispute will happen because because of the implementation of the articles or bylaws or from intra-corporate relation. Kaya nga sinabi ko na intra-corporate dispute. Sila lang, wala silang kalaban na third person. So, if it involves criminal offenses, it is non-arbitrable. So, binding effect, obviously, yung arbitration award will be binding on the arbitration agreement pala will be binding on the corporation, its directors, trustees, or officers, etc. So, kung may arbitration agreement na naka-incorporate sa articles, all of the members of the corporation should abide by the arbitration agreement. So, enforceability, remember, to be enforceable, yung arbitration agreement should indicate the number of administrators and the procedure for the appointment of the arbitrators. So, yung power to appoint yung arbitrators will be granted to an independent third party. So, hindi ang mga members ng corporation ang pipili ng arbitrators, kundi independent third party. So, if the third party does not appoint yung arbitrators within the specified period, the parties may request, yung mga parties in conflict may request the SEC to appoint yung arbitrators. In any case, arbitrators must be accredited. Meron silang procedure for accreditation of arbitrators. So, anyway, arbitration tribunal, kasi nga marami sila, kaya nga tribunal, it can rule in its own jurisdiction, meaning it can determine whether or not it is qualified to here arbitrate yung dispute. Pwede niyang sabihin, ay, sakop ko yan, ay, hindi ko sakop yan, etc. Depending on the arbitration, depending on the offense. Syempre, intracorporate lang kasi ang ano niyan ang sakop nila. And also, pwede rin silang mag-decide dun sa questions regarding the validity of the arbitration agreement as found in the Articles of Incorporation. So, kung merong intracorporate dispute, pinasok nyo kaagad sa RTC, merong arbitration agreement sa articles. Remember, class, i-dismiss lang ng regional trial court yan. So, kung merong arbitration agreement, sundin nyo muna yung arbitration agreement, whatever the provisions are, bago kayo mag-file ng case sa regional trial court. So, anyway, yung arbitral tribunal can grant interim measures. So, kumbaga, in the meantime na pending pa yung dispute, pwede siyang mag-issue ng mga orders para ma-prevent yung damages. Like, let us say, bawal mo nang ibenta yung stock, bawal mo nang i-register, etc. etc. Yun ang mga interim measures that the arbitral tribunal can exercise. So anyway, also remember that arbitral award shall be executory after the lapse of 15 days from receipt by the parties. So, file a bond or issuance, appellate court can issue an injunctive writ para ma-stop yung arbitral award. So, what else? Party list organizations, wala nang jurisdiction dyan ang SEC, transferred na sa COMELEC. COMELEC will promulgate implementing rules for the transfer of jurisdiction. So, special corporations under 183. So, this will be governed by the Bangko Sentral and Insurance Commission. So, ano ba yung mga special corporations na to? Banks, non-bank financial institution, insurance companies. What else? Yung legislative power to amend, meron siyang limit. So, it cannot impair obligations of contracts and vested rights. So, pagka na-acquire na ng stock ng corporation, stockholder, member, director, trustee, officer, yung mga rights na to, yung rights already acquired cannot be removed or impaired by the dissolution of the corporation or the amendment of the revised corporation code or any part of the revised corporation code. Kasi nga, vested na yung right. So, kung nabigay na sa kanila yung right, hindi mo pwedeng basta-bastang bawiin by the dissolution of the corporation or by the amendment of or repeal of the revised Corporation Code of the Philippines. And also remember that yung vested right survives even the dissolution of the corporation. Dissolved na yung corporation pero nandiyan pa rin yung vested rights niya. So halimbawa, ang corporation mo is an educational institution. Tapos yung kanyang charter, yung kanyang corporate existence expires in the middle of the school year. Pwede pa ba siyang mag-continue na magklase? Yes, kasi vested right na ng mga students yan, ng corporation yan, natapusin yung kanilang classes. Even if, as long as yung enrollment for the classes were made prior to the dissolution of the corporation. So, what else? Of course, a corporation must be paid sa kanyang property that is taken by the government. So, payment of just compensation. So what else? A separability clause. If any provision of the revised corporation code is unconstitutional, declared unconstitutional, hindi yung buong revised corporation code ang unconstitutional. Yun lamang dineclare na provision. Kaya nga separability clause, isa-separate natin yung invalidated provision. But other provisions are in full force and effect. So, in 185, remember, the revised corporation code will apply to all lawfully existing corporations, especially even yung mga foreign corporations already licensed. So, kung incorporated ka under the corporation code or BP 68, Batas Pambansa Bilang 68, ikaw ay nag-a-apply pa rin sa yung revised corporation code and also yung mga foreign corporations na nakakuha ng license under the corporation code. So anyway, kung license ka under the corporation code, you will be deemed to be licensed under the revised corporation code. Same is true with a corporation incorporated under the corporation code. Incorporated pa rin yan under the revised corporation code under the same terms and conditions, but always subject to the provisions of the revised corporation code. So kung may bagong requirements na binigay, the corporation has 2 years to comply with the said requirement. Bagong requirement under the revised code, not more than 2 years from the effectivity of the corporation code. So 187, this yung revised corporation code is an express repeal of the former corporation code or Batas Pambansa bilang 68 enacted May 1, 1980, as well as other presidential decrees, issuances, orders, etc. Repealed lahat yan. Express ang repeal because the repeal is provided by 187. And the revised corporation code became effective February 23, 2019. So that is it for the revised corporation code of the Philippines. Please prepare for your final exam. Good luck sa inyo class. So anyway, good night class, and thank you.